Copyright registration myths.
If it has no copyright notice, it's not copyrighted.
This actually used to be true, but it no longer is. Many works published before 1978 that didn't have the copyright notice lost their copyright protection. But since 1989, it is no longer mandatory to have one. There are two advantages to placing a copyright notice on the work. The first is that it may deter piracy, and the second is that the infringers are then legally not able to claim an innocent mistake. So if you use something that's clearly copyrighted, you are committing a willful infringement, and that can be very costly.
If it's not registered, it's not copyrighted.
Any work is automatically copyrighted the moment it's created in tangible form. One of many advantages of registration is that it makes it easy to prove ownership and the dates of creation or publication. A timely registration provides many legal rights to the owner. But even if they didn't register at all, the work can get registered at any time during the life of the copyright.
If it's not published, it's not copyrighted.
Copyright covers published and unpublished works equally. The only requirement is that the work is put into a tangible form. So words need to be written down and a photo should be taken, not just imagined.
There is no need to register copyright.
Well, technically, there is no need to register copyright because your work is protected immediately the moment it's created. But as a copyright owner, you miss out on much legal protection that you could otherwise enjoy. Not having your work registered on time greatly reduces the types of damages that you could possibly collect when suing someone over your copyright.
I can mail it to myself as proof of copyright.
This is called the poor man's copyright registration, and it's basically worthless. First of all, it is pointless because just having the work in tangible form is what gives you copyright protection. The contents of the envelope can be substituted at any later date, so that's hardly proof of anything. Secondly, mailing it to yourself is no substitute for registration. Just pay a few bucks and register your work with the Copyright Office right away, so you can rest assured that you have full legal protection.
Anything can be copyrighted.
Actually, there are quite a few things that can't be copyrighted. Ideas, facts, and laws are not eligible. You can't copyright anything that's already in the public domain. Any works created by the US federal government cannot be copyrighted. Individual state governments have that right, but they rarely use it. Names, titles, short phrases, and expressions are also not eligible for copyright protection. However, some catchphrases and company names do have protection, but this has to do with unfair competition laws. This is done by registering a trademark, and this provides a right to use those words or phrases only within a specific industry.